Welcome to Week 5. In Week 5, you will learn about wages, hours, and pay equity, benefits, unions and collective bargaining, and occupational safety and health. The Fair Labor Standards Act is a law that establishes a federal minimum wage and requires premium pay for overtime work. It also sets out work hour limitations for minors. The FLSA applies to virtually all employers. The FLSA contains a series of wage and hour laws that require employers to pay employees at least the minimum wage and pay overtime for hours worked in excess of 40 in a week. Many states require employers to pay a higher minimum wage than does federal law. Some also require that the payment of overtime for hours worked in excess of 8 in a day. In those cases, employees must be paid according to the law that requires employers to pay the higher amount. The FLSA also sets limits on the number of hours employees may work in a day or week. In addition, the FLSA regulates hours of work for minors and restricts minors from working in hazardous jobs. Many states have stricter limits on hours of work for minors in jobs they may be hired to do than does the federal law. The FLSA accepts executive, administrative, and professional employees, outside salespeople, and certain computer professionals from coverage of the minimum wage and overtime provisions of the Act. Certain other jobs are also specifically accepted from minimum wage and overtime coverage. In addition, certain learners, apprentices, and trainees may be paid less than the minimum wage with permission from the Commissioner of Labor. Tipped employees may have up to 50% of their tips credited toward payment of the minimum wage. The law is administered and enforced by the U.S. Department of Labor Wage and Hour Division. Employees can file a claim for unpaid wages with a DOL within 2 years of a violation. If the DOL doesn't sue on your behalf, or if you do not file a claim with the DOL, you may bring your own lawsuit. If you win, you can recover twice the amount of your unpaid wages and be reinstated to your job with back pay and full benefits if you were fired in retaliation for seeking your FLSA rights. Employers can also be fined up to $10,000 for a child labor law violation. In the next slide, you will see examples of wage-eligible work. In this slide, you will see examples of compensable and non-compensable time for non-exempt employees. For example, time that you cannot earn payment for work would be traveling from home to work, but you should be paid for traveling between work sites. Now let's talk about categories of exempt employment. Certain questions must be answered in order to categorize an employee exempt. An executive employee is an employee whose primary duty is to manage the enterprise, department, or other subunit of a company. You are an executive if you spend at least 80% of your time, or 60% in retail and service industries, managing a department or subdivision and or directing the work of 2 or more subordinates. Have the authority either to hire and fire or to give recommendations regarding hiring, firing, and promotion of employees. Routinely rely on your own discretion and are paid at least $155 a week, not counting any room and board or other facilities, if any, that are provided by your employer. An administrative employee is an employee who performs office or non-manual work directly related to the management policies or general business operations of an employer. You are an administrative employee if you spend at least 80% of your time, or 60% in retail and service industries, doing office work, or are on the administration of an educational institution, or perform tasks requiring special training or experience with only general supervision or exercise general supervision over others, or regularly help your employer or an executive or another administrative employee. Routinely rely on your own discretion and are paid at least $155 a week, not counting room and board and other facilities, if any, provided by your employer. A professional employee performs duties that require an advanced type of knowledge in a field of science or learning, that requires invention, imagination, or talent in a recognized field of artistic endeavor, or that involves the teaching activity of imparting knowledge. You are a professional employee if you spend at least 80% of your time doing work that requires an advanced degree or recognized artistic talent, are a certified teacher in an educational institution, and/or do work that is primarily intellectual, routinely rely on your own discretion, and are paid at least $170 a week. In general, and in addition to the various duties tests, employees must be paid on a salary or fee basis in order to be considered exempt. This means that employees receive predetermined amounts of compensation that cannot be reduced due to variations in the quality or quantity of work performed. With certain exceptions, salaried employees must receive their full salaries for any work weeks in which they perform work, regardless of the number of days or hours worked. Failure to do so may cause loss of exempt status. There are a few instances in which an employer can deduct pay from an exempt employee. These scenarios are listed here. If an employer improperly deducts wages from a salary, consequences must be assessed. The consequences for making improper deductions from the salary of an exempt employee can be far worse than simply having to reimburse the employee for the improperly deducted amount. Under the federal regulations, an employee who is subject to an improper deduction is not paid on a salary basis. Since payment on a salary basis is a prerequisite to exemption from overtime requirements, the exempt status of that employee may be lost. This means the employee would be entitled to overtime compensation for hours worked in excess of 40 in each week. The employee will be entitled to back overtime wages for a period of 2 years or 3 years if the violation is found to be willful. Since employers typically do not record the exact hours worked by exempt employees, the employee's testimony or personal records may be used to establish the number of overtime hours. Now we must discuss laws put in place to protect the employee from inequitable wage practices. The Equal Pay Act is a law that prohibits employers from paying a person of one sex at a lower rate of pay than a person of another sex for performing substantially equal work within the same establishment. In order for an employee to establish a prima facie case, he or she must show there is someone of the opposite sex working within the same establishment who receives a higher pay rate for performing work substantially equal to that of a coworker. This law is administered and enforced by the EEOC. An employee may file a claim with the EEOC, which must bring a lawsuit within 2 years of the violation. You may bring a private lawsuit rather than filing a claim with the EEOC. However, once you file a complaint with the EEOC, you may bring a private lawsuit only if the EEOC doesn't sue on your behalf. If you win, you can be reinstated or promoted. You can get double your pay. You can be awarded attorney's fees and court costs, and the court can order your employer to stop the practice. Your employer can also be fined up to $10,000. Fines can be greater and prison sentences imposed for subsequent willful offenses. Go to the supporting lessons links to the web or other media tab to watch video of the inception of the Lilly Ledbetter Fair Pay Act. In order for an employer to prevail, the employer must prove that the employer has a seniority system, a merit pay system, a system that bases pay on the quality or quantity of production, or some other factor than sex. ERISA is a federal law that governs most employer and labor union-sponsored benefit plans, including pensions, but not government employer plans or social insurance programs. ERISA has specific requirements regarding plan participation, vesting of employer contributions, and funding of plans. In addition, it has numerous reporting and disclosure requirements that depend on the kind of pension or retirement plan in question. Annual reports to employee plan members must include a statement of total benefits and the percentage of benefits that are fully vested. Employers must also provide regular reports to the U.S. Treasury Department, the IRS, and the Pension Benefit Guaranty Corporation. The law is administered and enforced by the U.S. Department of Labor, the U.S. Treasury Department, the IRS, and the Pension Benefit Guaranty Corporation. You may bring a private lawsuit if your ERISA rights are violated. If you win, you are entitled to restoration of full benefits and attorney's fees. Your employer can also lose his tax exemption for the plan. Intentional violations of reporting and disclosure requirements can result in a fine of between $5,000 and $100,000 and imprisonment for up to 1 year. COBRA, the Consolidated Omnibus Budget Reconciliation Act, is a law that requires employers who have group health insurance plans and at least 20 employees to offer continuation coverage under certain circumstances in which employees and other beneficiaries would otherwise lose health insurance coverage. In most cases, continuation is for 18 months, but it can be up to 36 months. Employers are required to notify employees of the COBRA rights both when they join the group health insurance plan and when their employment terminates. The employee must pay the entire premium. The employer is no longer responsible for making contributions. COBRA continuation rights may end prematurely either when the covered individual fails to pay the premiums or when he or she becomes eligible for membership in another group health insurance plan. The law is administered and enforced by the IRS. If your employer doesn't notify you when you're covered dependents of your right to COBRA continuation benefits, he can be held liable for any medical expenses you incur as a result of your lack of insurance or underinsurance. The fundamental rights conferred by the NLRA, often termed Section 7 rights, include the right to self-organization, form, join, or assist labor organizations, bargain collectively with their employer through representatives of the employee's own choosing, go on strike, engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection, or refrain from such activities. Employers do not have the right to participate in, interfering with, restraining, or coercing employees in the exercise of their rights under the Act, dominating or interfering with the formation or administration of a labor organization, discriminating against employees for the purpose of encouraging or discouraging membership in any labor organization, retaliating against employees for filing charges or giving testimony under the Act, and refusing to engage in collective bargaining. Labor organizations must refrain from restraining or coercing employees in the exercise of their rights under the Act, causing an employer to discriminate against an employee for the purpose of encouraging or discouraging membership in a labor organization, refusing to engage in collective bargaining, broadening labor disputes to include neutral employers, charging excessive or discriminatory initiation fees or dues, causing an employer to pay for work not performed, and picketing for more than 30 days for the purpose of obtaining union recognition. In this slide, the General Counsel of the NLRB must use these elements to establish a prima facie case. If a prima facie case is established, the NLRA is violated unless the employer can show that the same decision would have been made regardless of whether the employee engaged in protected activity. Pleasant View Nursing Home versus NLRB, 2003. A union negotiated with the nursing home for a new collective bargaining agreement. The home had a serious and long-standing problem with staffing. One of the employer's objectives was to raise pay to allow the home to compete for workers more successfully. The parties negotiated over a number of issues including pay rates, union security, collection of initiation fees, and the buyback of pension and paid holiday provisions. During the course of the negotiation, the employer decided to implement an increase in starting pay and to cease collection of union initiation fees. After about 5 months of negotiations, the employer declared an impasse and stated that it intended to implement its final offer on the topics that remained in dispute. The union called a strike, but the strike collapsed after one shift. The employer subsequently withdrew recognition from the union. The NLRB concluded that the nursing home had committed numerous unfair labor practices in the course of the negotiations and sought court enforcement of its remedial order. Number 1. What was the legal case in this issue. What did the court decide? The issue was whether the employer violated the National Labor Relations Act by failing to bargain in good faith. The court enforced the NLRB's order in part. The board's conclusions that the employer committed unfair labor practices when it stopped collecting union initiation fees and when it unilaterally increased starting wages during negotiations were affirmed. However, the court reversed the NLRB's conclusions that the employer had committed unfair labor practices by failing to negotiate in good faith regarding the holiday and pension provisions, insisting on its position regarding the initiation fee collections clause to the point of impasse, and implementing a final offer prior to a valid impasse. Number 2. What was the problem with the employer raising the wages of some employees? Establishing rates of pay acceptable to both parties is generally a key issue in labor management negotiations. When an employer unilaterally decides this issue in the course of negotiations, even when the decision is to raise wages rather than to lower them, it frustrates the bargaining process and conveys to employees that a union is not really necessary. Thus, unilateral changes during negotiations, even after the prior collective bargaining agreement has expired, typically violates the NLRA. Unilateral changes during negotiations are sometimes allowed if prompted by economic exigency. To prove that this condition exists, the employer must show a compelling business justification and not merely a business rationale or necessity. The nursing home was unable to show the existence of economic exigency because its problem with non-competitive pay levels was long-standing. The measure was not needed to ensure that the facility would have sufficient staff to continue to operate, and the employer waited 2 months between when it first requested the wage increase and when it implemented it. Number 3. How do we know whether an employer has bargained in good faith? Why did the court reject the NLRB's conclusion that the nursing home did not bargain in good faith regarding the buybacks of pension and paid holiday provisions? It is difficult to determine whether good faith bargaining has occurred. If an employer meets the procedural requirements, the employer need not make concessions to the union or reach agreement on an issue in order to have bargained in good faith. The NLRB cited as evidence of the lack of good faith bargaining the facts that the employer did not alter its initial position. A management negotiator stated in one session that the issue was non-negotiable, and the employer unilaterally implemented an increase in starting pay that it intended to fund through the buybacks. The court emphasized that good faith bargaining does not require the making of concessions. The court characterized the employee's stance as hard bargaining rather than lack of good faith bargaining. The statement by a negotiator that the issue was non-negotiable was viewed as substantial evidence, but the court emphasized that the employer's conduct rather than its bargaining rhetoric is the telling factor. Negotiations continued for 2 months after the statement was made. Another statement by a negotiator that the employer just couldn't come up with a different plan, which had been cited by the NLRB as further evidence of lack of good faith, was interpreted by the court as signaling the employer's willingness to consider alternatives. Lastly, the unilateral increase in starting wages was viewed by the court as not relevant to the issue of whether the employer bargained in good faith on the buyback issue. Although the employer had linked the rationale for its buyback proposal to the pay increase, these were separate issues, and no unilateral change was made regarding implementation of the buyback plan. Why did the court conclude that the nursing home did not reject an agreement based on non-mandatory topic of bargaining? Upon security provisions, union security provisions are regarded as conditions of employment and treated as mandatory topics of bargaining. In contrast, the collection of initiation fees relates more closely to the internal affairs of a union and is not a mandatory topic of bargaining. Both of these issues were taken up in the negotiation, and the employer's negotiating stance linked them together. The employer demanded that either the union could receive the union shop in exchange for elimination of the initiation fee clause, or it could keep the collection clause. The Occupational Safety and Health Act applies to virtually all employers. The Act requires employers to comply with safety and health standards set by OSHA. A general standard requires employers to ensure that their workplaces are free from ordinary hazards that are likely to cause serious injury or death. Specific standards apply to particular industries. There are also requirements regarding employees' basic comfort and needs, such as general housekeeping requirements, provision of drinking water and sufficient toilet facilities, and maintenance of a temperature range that is not likely to cause illness. The law is administered and enforced by OSHA. OSHA has the authority to conduct inspections of workplaces on its own initiative or in response to specific complaints. When a complaint is made, OSHA can investigate. If a violation is discovered, the employer will be issued a citation and will be ordered to correct the violation. An employer can be fined up to $1,000 a day for failing to correct a violation. He may also be fined up to $7,000 for a serious violation and up to $70,000 for a willful violation. If you successfully sue your employer for firing you in retaliation for reporting OSHA violations, you may be awarded double the amount of your lost wages, as well as punitive damages. Please go to the supporting lesson links to the web or other media tab to watch the story of OSHA. There are several guidelines that OSHA uses to determine if the Act was violated. An applicable standard exists. The standard was not complied with. One or more employees were exposed or had access to the hazard, and the employer knew or should have known of the hazard. There are several guidelines that OSHA uses to determine if the General Duty Clause was violated. The General Duty Clause is the act that places basic responsibility for workplace safety with employers. This clause can be invoked for enforcement purposes in the absence of standards regulating the specific hazard involved. 1. A workplace hazard was allowed to exist. 2. The hazard was or should have been recognized by the employer. 3. The hazard caused or was likely to cause death or serious physical injury. And 4. Feasible means exist to abate the hazard. A workplace safety program is a comprehensive program established by employers to identify and abate unsafe conditions in their workplace. 5 elements of a workplace safety program are as follows: demonstrate management commitment, obtain employee involvement, perform worksite hazard analyses, prevent or control hazards, and train employees in safety and health. 1. Demonstrate management commitment. Develop a safety and health policy statement. Communicate with employees about safety and health issues. Establish objectives for safety and health performance. Measure performance. Assign responsibility for health and safety activities and outcomes. Provide sufficient time, authority, and resources to safety and health staff. Reward good safety and health performance. Enforce safety rules, and show direct involvement of upper-level managers in safety issues. Obtain employee involvement. Utilize safety and health committees. Work closely with union representatives on safety issues. Involve employees in identifying and solving safety problems, and encourage expression of safety concerns. Perform worksite hazard analyses. Consult with outside experts. Review OSHA required records for patterns. Carefully investigate accidents and near misses looking for root causes. Conduct self-inspections, job hazard analyses, and consider health and safety ramifications of changes in equipment, work processes, and staffing. Prevent or control hazards. Give priority to eliminating or abating hazards. Utilize engineering, work process, and administrative controls, training, personal protective equipment, medical and exposure monitoring. Properly maintain facilities and equipment. Engage in emergency planning and preparation. Ensure that medical surveillance and treatment are readily available. Train employees in safety and health. Workers' compensation is a state law that provides the exclusive remedy for employees who suffer accidental injury, illness, or death from their employment. Keep in mind that each state's law differs depending on the state. In this slide and the following slide, you will see basic tenets of the workers' compensation law. In a perfect world, the ideal progression of workers' compensation would be: your employer buys workers' compensation insurance, or if he can prove he has the necessary financial resources, insures himself, which essentially means he pays claims out of his own funds instead of buying insurance. 2, you get hurt on the job or contract a work-related illness. 3, your employer's insurance carrier immediately starts paying your medical, hospital, and surgical bills. 4, you file a claim for workers' compensation, and your employer's insurance carrier immediately begins paying your benefits based on a percentage of your average weekly income, usually 66% of gross, up to a maximum cap in most states, but in any event less than your full income, since you don't have to pay income taxes on workers' compensation benefits. 5, the State Workers' Compensation Board quickly approves your claim, assuming they find it to be work-related. 6, your employer's insurance carrier continues to pay your medical bills and income benefits for the duration of your disability. 7, as your condition improves, you return to light work. And then 8, eventually you are back to full duty and off workers' compensation entirely. Or, if you can never return to full earning capacity, workers' compensation makes up most of the difference between what you were able to earn before the accident and what you were able to earn with your disability. Wright versus Beverly Fabrics, 2002. An employee was injured when, on her day off, she went to her place of employment to sign a condolence card and make a contribution for 2 other employees who had lost family members. She had been standing by a set of shelves talking to coworkers when the shelves tipped over. She helped keep the shelves from falling on anyone, but in the process hurt her back. It turned out that the shelves were missing some necessary braces. She sued the employer for negligence and was awarded over $1.5 million. The employer appealed, claiming that a negligence suit was barred by the state workers' compensation statute. 1. What was the legal issue in this case? What did the court decide? The issue was whether the employee's injury arose out of and in the course of employment. The court decided that it did and reversed the jury's award to the plaintiff on her negligence claim. Workers' compensation was the employee's exclusive remedy. 2. What is the evidence that she was injured in the course of employment, arising out of employment? Course of employment refers to the time, place, and context of the injury. Even though the employee was not on the clock and was in the workplace of her own volition for the purpose of lending support to coworkers who had lost family members, the court still concluded that the injury was in the course of employment because the act of grabbing the shelf was in furtherance of the employer's business. In the court's view, she was doing no more than what a reasonable employer would expect from a reasonable employee in her position. It did not matter that her acts on behalf of the employer were combined with personal acts and undertaken outside of work hours. And since it was taking an action furthering the employer's business that caused the injury, her injury arose out of employment. 3. Why didn't the restrictions on workers' compensation coverage for voluntary participation in social activities apply? The California's workers' compensation statute excludes from coverage injuries that arise out of voluntary participation in any off-duty recreational, social, or athletic activity not constituting part of the employee's work duties, except where such activities are a reasonable expectation of employment. The court was held that the employee was not hurt while engaging in the social activities of signing a card and talking to coworkers, but rather when she endeavored to hold up the shelves, an activity reasonably expected by the employer. Was the case correctly decided? It can be questioned whether the employer had any reasonable basis for expecting the employee to put herself at risk by intervening and whether she might have been motivated by something other than concern for the employer's property. A customer encountering the same situation might very well have reacted in the same manner. And is the court suggesting that Wright might have been disciplined or fired if she did not act as she did? If not, what does it mean that her actions were a reasonable expectancy of employment? On the other hand, eligibility for workers' compensation is liberally construed, meaning that doubt should be resolved in the direction of coverage. While under the facts of this case, that included the employer's negligence for not properly bracing the shelves, it would have been more favorable to Wright to not be covered by workers' comp. This will not always be the case, and workers' compensation provides injured employees with at least a minimal remedy for their injuries. Secretary of Labor versus Beverly Enterprises, 2000. OSHA brought an enforcement action against the Beverly nursing home chain for exposing its nursing assistants to ergonomic hazards associated with lifting and moving residents. An administrative law judge, or ALJ, decided in favor of the company. The Occupational Safety and Health Review Commission considered an appeal of the ALJ's decision. Number 1. What was the legal issue in this case? What did the OSHRC decide? The issue was whether Beverly violated the General Duty Clause of the OSHA Act by allowing its nursing assistants to be exposed to a serious recognized health hazard. The OSHRC found that the hazard was once recognized by both the employer and the industry, and that it was causing or likely to cause serious physical harm. It reversed the ALJ's decision and remanded the case for further consideration of whether feasible means existed to abate the hazard, and Beverly failed to employ such means. Number 2. What is the evidence that back injuries due to lifting nursing home residents are recognized hazards? The incidence of lost work days for nursing home employees is more than twice the average rate for general industry, and Beverly facilities had injury rates 2 to 3 times the national average for nursing homes. Scientific studies of the effects of manual lifting of residents show it to be a risk factor for lower back pain. The company tracked lower back injuries and was acutely aware of their effect on workers' compensation claims. As part of a settlement with OSHA, it hired an ergonomist to study the problem. It instituted a lost time hotline to increase the awareness of lost time injuries at the corporate level. The company also instituted a program requiring employees to wear a back support device. Regarding recognition of the problem by the industry, the OSHRC noted that a hazard can be deemed recognized even though the hazard is common in an industry and the employer uses work practices similar to other employers in the industry. There was also sufficient evidence that experts familiar with the nursing home industry perceived the lifting and moving of residents to be hazardous. What is the evidence regarding the severity of these injuries? The OSHRC observed that it is the burden of the Secretary of Labor to show that if employees are exposed to a particular hazard, that it is likely to cause death or serious physical harm, not that an accident is likely. The OSHRC rejected Beverly's contentions that lower back pain is not serious physical harm because it is common, is typically short-term in duration, has numerous non-work causes, and usually consists of symptoms rather than observable tissue damage or other pathology. Conditions need not be permanent or entail detectable tissue or body damage in order to be considered serious physical harm. It is enough that lower back pain effectively disables many employees, in some cases for long periods of time. Number 4. Does it appear that there are feasible means of lessening the hazard? This is the issue on which the case was remanded. It can be difficult in cases involving ergonomic hazards to specify a particular set of measures that an employer should use, since responding to ergonomic hazards often involves a process of experimentation and a series of adjustments. Beverly had taken some steps already, although it seemed to have focused on personal protective equipment rather than engineering or administrative controls. Certainly, the need to move patients who are unable to assist in the process is a reality that nursing homes cannot change. However, it may be necessary to invest more heavily in mechanical lifting devices and to have sufficient staffing that would allow for more than a single nursing assistant to be involved with moving non-ambulatory patients. The settlement that Beverly reached in this case provided for greater use of mechanical lifting devices and more training in proper lifting techniques. Number 5. What are the practical implications of this case for employers? Would employers be better off with a specific standard detailing what is expected of them? The case shows that the general duty clause of OSHA is indeed applicable to ergonomic hazards and that employers face potential liability for ignoring these conditions. Ironically, after enlisting the help of Congress to defeat an ergonomic standard, employers might have been better off with a specific standard that clearly outlines the extent of their responsibilities.